Welcome to Settlement Checkpoints, when and how you can get your case resolved. I'm Phillip Vondra, Chair of Beverly Hill Bar Association's Personal Injury Law Section. I am delighted to introduce our speakers today, Brigitta Cymerint and John Davidi. Brigitta Cymerint is an attorney with Panish, Shea, Ravipudi, LLP, who focuses her practice on catastrophic personal injury and wrongful death matters across California. She brings to her work a deep commitment to consumer advocacy, shaped by her leadership at Southwestern Law School and her early experience clerking at the firm. Jonathan Davidi is a trial attorney at Panish, Ravipudi LLP, who represents clients in complex personal injury, wrongful death, and product defect cases, securing more than 100 million in verdicts and settlements. A skilled trial lawyer, recognized as a super lawyer rising star and best lawyers, ones to watch honoree. He maintains an active practice across California, Nevada, and Texas. And now let's get started.
Thank you, Phillip. Welcome, everybody. We have a slide deck that we'll be putting up for you just here in a minute. Okay, and as Phillip said, my name is John Davidi. My colleague Brigitta Cymerint is on here as well. Today, we're going to be talking about settling cases. And a lot of people, I think, like to talk about trying cases. And there's a lot of CLEs and webinars and conferences about trying cases and being a trial lawyer and sharpening your trial skills. When in reality, obviously, that's important and it helps get cases settled. But whatever the statistic is, 90, 95, 98, 99% of cases settle. And I'm sure if you ask a lot of judges or settlement judges, they say 100% of cases should settle. So when the reality that we live in is that 95+% of cases do settle, we have to sharpen those skills too and look at when and why and how we can maximize the results for our clients. Brigitta and I are both plaintiffs lawyers, so a lot of this will be kind of tailored to the plaintiff's bar, but a lot of it will apply even if you don't do personal injury, and to the defense as well. So here are the 6 key moments that we'll be focusing on to apply pressure and get a case resolved. They're kind of like checkpoints. That's the name of the title. We'll go through each of them a little more in depth, obviously. But before we do, what I want to say is these are obviously not the only moments that a case can settle. And within each of these, there are many moments where a case might be ripe for settlement. There might be some that we missed. Every litigation is different. Every case is different. Whenever we sign a client up, they ask how long it's going to take. And I say, we're going to get a trial date probably within a year and a half or 2 years because the courts are backed up. And then I say, but a case can settle at any time. You never know when the mediation is going to come. You never know when the defense is going to be ready. Our job as the plaintiff's lawyers is to apply pressure to try to accelerate that process as much as possible. And so we're going to start, even though we're litigators, most of what we do is litigation. Let's start with before filing a lawsuit and the pre-litigation phase and what you can do to get your case ready to resolve pre-litigation. Brigitta?
Hi, everyone. So like John said, the first time in your case where you should be thinking about settlement and settlement should be on your mind is prior to filing the lawsuit. As you all know, lawsuits are expensive, they take a long time, and this is a good time for you to package a persuasive demand and lay out your case clearly. So just so you know where to send it, you should be sending it to the email address or physical address designated by the liability insurer. If you know your insurance rep, send it directly to them. But the best practice is send it to everyone. Send it to the defense attorney, the adjuster, the insurance company. And if the defendant is not personally represented, you can send it to the defendant as well. At that time, they can either accept your demand, they can ask you for clarification. They can ask you for additional time, information. They can also ask you for more details regarding your client. And if they don't want to accept the demand, they need to tell you in writing prior to the expiration date in your demand. The rejection alone does not automatically mean it's going to be a bad faith case or an open policy, but it's just another thing for the court to consider if you do try to pursue a bad faith case later on. And this slide just shows language you can use. You should use the exact language of the code, which is, plaintiff is offering to settle his claim prior to filing a lawsuit in the disclosed policy limits. And you have, 30-day deadline to respond. So CCP 999 is the time-limited demand prior to filing a lawsuit. This is the code you can use in your demand. And there are 7 requirements for these demands. So first, you want to state that it's time-limited. It should be not less than 30 days if it's by mail, fax, or certified mail, and 33 days otherwise. Number 2, you want to have a clear offer to settle all claims within the policy limits, including satisfaction on all liens. Number 3, it should be an offer for a complete release from the claimant for the liability insurers from all present and future liability for this occurrence. Number 4, you want to clearly state the date and location of the loss. This is important, and we usually put this in. So we'll have like an introduction, and then we'll have facts about the case, and I will write like the accident happened on this date at this time. These were the parties. This is where it happened. Number 5, you want to have the claim number if you know it, and that would be in the very beginning. You want to put the claim number, the parties, and the date of liability. And then number 6, you want to have a description of all the injuries. So this would go in a damages section, and we lay it out very clearly. This is the injuries our client suffered, and this is all the treatment they've gotten. This is what they're still continuing to suffer from. And then number 7, you want reasonable proof. This might include medical records, bills, anything sufficient to support your claim. And then, on this slide, again, is just a way to state it in the demand, and you can use the code in your demand letter. This settlement is made pursuant to Code of Civil Procedure Section 999.
And in fact, you should use the code, and you should use that language. And if there are any of you who haven't read 999 and 999.1 at SEC, it's important that you do, because look, the reality is in practice, if you don't follow the code to the letter of the law, and there's a $250,000 policy and your case is worth more than $250,000, they're probably still going to pay you. They're going to accept your demand. But this matters because what if you have the potential for an open policy and bad faith? You don't want it. You don't want their argument to be, well, you didn't meet this one little criteria of 999, and then your bad faith case is dead on arrival. So it's just good practice. It also is all these things should be included in your demand anyway, but it's good practice to also lay it out.
And the pre-lit demand, it is a firm deadline. And so it's a way to set up your case strategically with the defense. It automatically builds pressure prior to filing your lawsuit because you're clearly outlining the facts, liability, and damages. So it's a way to force the carrier to do a realistic evaluation early on. It's beneficial for defense and for your client because, like we said earlier, litigation is long and it's expensive. So it's good to set up your case from the start well using a pre-lit demand.
And another thing I like about this is, like Brigitta said, it triggers a response. And every demand pretty much that you make, pre-lit or lit, will trigger a response because insurance companies want to respond. They don't want to be seen like they're acting in bad faith or ignoring you. In addition to forcing the carrier to realistically evaluate the claim, making a pre-litigation demand might give you more information before filing the lawsuit that could be helpful. For example, if you have a case where liability might be tricky, or you don't know whether liability is tricky or not, and you have some big damages, the carrier might give a very detailed response to your demand saying, here's why we think you're going to lose. Here's why we think the damages aren't legitimate, whatever it is. And now you can take a moment to evaluate your case. Now, a lot of times, carriers ask for extensions, ask for more information, et cetera. That's usually a judgment call. That's not something that we could teach you here. You want to give them as much information as possible pre-litigation. We had a case recently where it's a huge injury and there was a good policy, and we think that the policy really should have been paid. We gave them 30 days. It was around the holidays. They asked for an extension. We granted an extension. They asked for some more records. We gave them more records. They asked to speak with the mother of the plaintiff pre-lit, and we even granted that, which usually we wouldn't do, but this was a case where we wanted to give them a real opportunity pre-litigation to pay the policy limits in good faith. And they didn't, and they denied the policy limits demand, which was a little bit of a surprise. But now we're going to litigation feeling a lot better about a potential open policy or bad faith case because we gave them so much that they asked for. And at the end of the day, they said it wasn't enough. We were really being reasonable. We were really trying to act in good faith, and it really seemed like they just didn't want to pay. So I feel more confident going into an open policy or bad faith case because I gave them so much, as opposed to if it was just a 30-day demand and I didn't give them any extensions and they ended up denying it there. So all things to consider. Ultimately, we're all lawyers. We need to use our judgment. That's part of what we do. Okay. The next checkpoint that I like is right after filing the lawsuit. I think there are a lot of people who will file the lawsuit and want to do some discovery and do a deposition, et cetera. That's totally fine too. That's actually our third checkpoint. But sometimes right after filing a lawsuit, especially if the policy limits kind of align with the extent of the injuries, is a way to get it done quickly. And a lot of times we'll send a 998 offer right after filing the lawsuit on the earliest possible date. What changes when you go from pre-litigation to litigation is that, one, usually there's now a defense lawyer. A lot of times there isn't one in pre-lit. And two, usually there's a new adjuster. You'll now have a litigation adjuster usually on the case. Litigation adjusters typically are a little bit more sophisticated. They understand risk a little bit better. You're getting a new set of eyes on the case. There's a new calculation that's going on behind the scenes for the insurance where you can make your demand and maybe it'll spark conversation, maybe it won't, but it's worth a shot. I would keep it at the same demand that you had pre-litigation, for example, if it's a policy limits demand, but give it a shot to get it done right after. And here, I think this next slide is where we'll talk about 998. And like I mentioned before, I like to do it in the form of a 998. A couple of reasons. One, I think you come from a position of strength when you do a 998 really early. Obviously, for those of you who may not be as familiar, under 998, it's a statutory offer to compromise. And if you're a plaintiff and you make this offer to compromise, the defense has 30 days to respond. If they reject it and you go to trial and get more than your offer, you're entitled to interest, 10% per year, and expert costs. So serving the early 998 does give you interest accruing a lot earlier, which is great. And we have a case right now where we served a really early 998. The trial is coming up in a few months, and we've accrued 2 years of interest on the 998 already, obviously, if we beat the number. The reasonableness of the 998 this early on depends. It depends how much you gave them pre-lit, depends how much information that they have. They might object and say, we don't have the deposition, we don't have the IME, we need X, Y, Z. A lot of times what we will do when we serve this early 998 is serve it with a cover letter that is essentially a demand letter. And in that, we'll say, if you want to depose the plaintiff, if you want to take the plaintiff's IME, we will waive the statutory notice requirements and make them available within the 30 days. They have maybe one time in my history of doing this has a defense lawyer taken us up on that. Usually they just ignore it and object anyway, but at least now we're coming off as good faith actors who are trying to be reasonable, and the 998 can seem more reasonable.
So the next part in your case where you should be paying attention to a possible settlement is after key depositions. John and I actually litigated a case last year. It's confidential, so we can't say the names of the parties or the amount that it settled for, but it was against a hotel. The plaintiffs were family members of two guests that were staying in the hotel. One of the guests' husband, I think they were separated at the time, he showed up at the hotel. He's not a registered guest. His name was not on the reservation. And despite that, the hotel employee gives him a room key. He goes up to the room and shoots and kills both guests that were staying there. So during discovery of this case, the hotel produces their written policies, and their policies are super clear. They spell out that staff is not allowed to issue any room keys to anyone whose name is not on the reservation. And beyond that, it also specifies that these policies are in place to emphasize guest safety and protect the people staying there. So then we go into depositions. We depose the employee who was there that day who gives this guy a room key. He admits under oath that he broke company policy. He admits to giving the key to someone who was not a registered guest, which, by the way, we also had video footage of. And he admits that he knows it violated their policies and that he was trained on the proper procedures that he was supposed to do. So at that point, even without admitting, we had liability. And so we chose to write a demand letter at that stage, and we attached screenshots of their safety policies. Immediately after that, we attached screenshots of the deposition testimony where the employee admits to violating those policies, and we lay it out side by side. So those violations are just undeniable at this point. We also had a section in the demand letter that discredited the defense's position that the hotel didn't have any liability, because obviously we had a lot of evidence that they are liable. We also addressed any suggestion of comparative fault, and we made it really clear that even if the shooter bears any fault, the hotel can't escape liability when it directly failed to follow their own safety procedures that were in place, designed to protect their guests. So we ended up settling the case for the full policy limits. So just, depositions are not just to gather facts, they create settlement leverage. So you should be using the production on discovery that you obtain with your depositions. Ask questions that you from stuff you obtained to gather, a case where you're building liability. I don't know if you have anything to say on that, John.
Yeah, I think, the first two checkpoints we talked about were nice, and it would be great if cases settle pre-litigation or right after filing a lawsuit and both sides save a bunch of money and everyone saves a bunch of time. But for the most part, if you have something a little bit complex, if you have something that's high value, if there are issues to the case, the carrier is going to want more information. They're going to want to investigate. They're going to want to take the plaintiff's deposition. They're going to want to do an IME maybe. They're going to want to see what the defendant's depositions look like. And a lot is being evaluated in these depositions, including who the attorney is, right? And that's something to think about when you're taking the depositions, is being totally prepared so that they go back to the carrier and say, this is a good lawyer who knows what he's doing. Getting the demand after, I think, the key depositions, that's probably the best time, because at this point, usually there's enough information. Written discovery has been completed. You could pull deposition testimony from the plaintiff about damages, from the defendants about liability, and put them in the demand letter. You need to show the carriers and the defense lawyers why you are going to win. You can't just say we're going to win. You have to actually pull it out of them. You have to pull the settlement out of them, is the way I like to think about it. And the way to do that is by showing them the actual evidence, and that it's not going to get better for them if things go to trial. What I will say is, if it's a case where liability is not really in dispute, you may consider doing this type of demand after the plaintiff's deposition, because really that's the key deposition here. Or if some treating doctors get deposed, that would be a good time to do it. If the defense hasn't noticed any and you think a treating doctor might be helpful, find a treating doctor to take their depositions, get some good deposition clips from them, and plug those into the demand letter so that, again, the insurance carrier knows what the exposure and the risk is in a case like this.
And we also usually include a little paragraph, it's on the slide here, of exactly what they're already in possession of. So you have plaintiff's written discovery, you have their deposition, you already did this, did that. So it's very clear all the information they already have, so they can't come back to you and be like, oh, we need this. We know exactly what you have already, and it's pretty clearly laid out. Another
And
thing, go ahead.
Go ahead.
Another thing I want to say is, what John was saying, being prepared going into depositions. The more prepared you are as a plaintiff's attorney from the start in every proceeding, in every interaction, every email, the more pressure builds on the defense that we are ready and we have all the information and we're going to show up ready every stage of the case, including trial. So it just shows the carrier and the defense attorneys the value of the case based on that.
And one thing I will say on Brigitta's second to last point, which was state in these demand letters everything that they have, everything that they've done 100%. And if they have been, slow to do anything or delaying, mention that too. We've offered the plaintiff up for deposition 3 times in the last 3 months and you failed to give notice. We've offered to make them available for an IME and you haven't taken the IME, to show that they're not really the good actor here. And they have their own reasons. Sometimes people are busy or just lazy or delay or whatever, but you want it all in writing again, because if this does one day go to bad faith, you want to have this well documented. But either way, you want to show them that you're on top of things. Hey, I remember 3 months ago, you said you wanted to take the plaintiff's deposition and I gave you some dates and you never responded. Things like that show that you're in control of the litigation and you know what you're doing.
Exactly. And I would also add, so let's say you have really good key depositions and your liability is pretty clear. I would steer away from more law trying to prove liability and just talk about the facts. Talk about exactly what happened in the case and lay it out clearly, because that, to me, that's stronger than doing a really long legal argument in your demand. You're just talking about the actual case and what happened, and you're showing that we pretty much have liability.
And the beauty of this type of demand letter, and especially at this point, is that you'll put the effort into it, you'll make it good as it should be, and then you can pretty much use it for your mediation brief. And a lot of times what we see is after, kind of this phase, there start to be conversations about a mediation. If it's a case that needs to be mediated and isn't a clear policy limits case, there start to be discussions. And sometimes even after, if you make the demand right after filing a lawsuit, sometimes the defense lawyer will say, look, it's a case we want to get settled. Let me take a couple depositions and let's get a mediation on calendar for a few months out. Great. But here is where they'll have a lot more information. And it's kind of ripe for a mediation around this point too. But the reality is that if you don't make the demand, they're probably not going to pay attention to anything. They're probably not going to propose mediation. There needs to be these little reminders and triggers, and you have to be a little bit of a pest, not too much, so that this case stays top of mind for the defense lawyer and for the adjuster, and you let them know we're not going to back down. We're going to try to get this case resolved. We're going to exhaust all efforts to do so before trial, and we're still going to prepare for trial. But whenever you're ready to come to the table, we're ready.
Yeah, and the way I think about it too is don't let them leave any stone unturned. Like, give them everything you have to lay out your case as good as you can. Okay, so the next stage that you should be thinking about settling is after the IME. Sometimes an IME will confirm what you already know. Your plaintiff has real injuries that were directly caused by the incident. When the defense doctor can't meaningfully dispute the mechanism of injury or causation, this tells you that your trial argument is going to be good and theirs is limited. That's valuable information to you. Conversely, even if the IME isn't great for your client, it's still clarity for you, and it shows you how far the defense expert is willing to go. It shows you what they actually have and sometimes what they don't have. So if causation is clearly tied to the incident and the defense doctor can't credibly break that chain, this is a really strong time for you to push for resolution before you incur all the costs and time of trial prep, experts, motions in limine, exhibit work, trial subpoenas. It just keeps adding up until trial happens. So this is a really good time for you to sit back and be like, okay, even their defense expert is agreeing with us. And we like to send a renewed demand at this stage, and you can attach the IME report and you can point out, even if the defense's own doctor confirms causation and plaintiffs continuing to suffer, this shows the carrier and defense that this is a good time to settle because our trial posture is much better than theirs, and it strengthens your case value. And then again, on the flip side, if the IME exposes some weaknesses, this is your moment to reassess the case's value. And it might be a practical time for you to settle, knowing how much, how many more costs you have coming up to trial. You have, experts and all these things. And it's like, if you see at this point that maybe we should settle here and not incur all those costs, you have a time to reassess the value of your case.
And I think this is especially helpful in a case where if the injuries are really big and the liability is really tough, this is especially helpful there because you'll have, if you have real good, objective, bad injuries, the defense doctor can't say anything, right? They're going to say, yes, they suffered this broken leg, they needed this surgery, whatever. And you have that. And now you have your damages kind of confirmed by the other side, and all that's left to argue is liability. And you say, hey, our damages are so big, this doctor that you hired, that you paid thousands of dollars to, agrees. And so even if we get 50% liability or 70% liability, the damages are so big that, this is a case that should settle for X or whatever, right? And again, same as depositions, good time after here to try to get into a mediation. As the plaintiff's lawyer, I never really like to propose mediation myself. I always want to wait for the defense to do so. They usually do because they want to, try to get it done. It's part of the course of action. They want to see if they could get any sort of discount off the policy. But making the demand is kind of a good way to start triggering in their minds that maybe we should mediate this case. And by the way, if you're the defense, if anyone on here is a defense lawyer, I don't know if all my years of practice I've ever had a case where a defense or a defendant made an offer just kind of on their own. It would be great if they did sometimes, we could get the ball rolling. Usually it's in response to a demand. But after these, checkpoints, the deposition and the IME, and you've gotten your written discovery down and you've got your subpoenas and your medical records, if you're a defense lawyer and the plaintiff's lawyer isn't making demands, or, they're the ones kind of dropping the ball and aren't being aggressive about it, you should propose a mediation. Be the aggressor, get a mediation on calendar, because you want your case to get settled for your client too before they spend a bunch more money. Because after this, it's really just experts. And that's when a case gets really expensive. So I think both sides know that, after this checkpoint 4, depositions done, IME done, subpoenas received, all that's left is experts. Maybe they're 6 months away. Let's get a mediation on calendar in the next 3 months or so and see if we can't get this resolved before we both spend a ton of money getting ready for trial. Okay, and speaking of expert discovery, another great time. This is usually on the cases that are more complex, a little trickier. Maybe you have an aggressive lawyer on the other side, an adjuster who doesn't like to pay. We've all been there. It happens. They want to see some expert depos. You got to get your experts ready, spend the money. But again, this goes to earlier when we were talking about the depositions. You need to be prepared so that you're taking a much better deposition than they are of your experts. And having these expert opinions, which don't really exist before expert disclosures, they might, in that you might have a life care plan, or you might want to show something at a mediation, or as part of a demand for confidential settlement purposes. But once you have this in sworn testimony and reports are produced and the picture of trial becomes a lot clearer, that's another good time to revisit it. Most of our cases, I will say, settle around expert discovery, in the middle of expert discovery, or after expert discovery and closer to trial, because the picture is painted. We know what the evidence is going to be at trial, and we've worked the case up. We've gotten the right experts. They know that we have a good case going forward. Sometimes we don't, and it's a good time for us to evaluate our case. And if the expert depositions don't go well, that's a conversation that we have with the client, and discuss, hey, maybe this is one that we need to settle, not one that we want to settle, right? Which hopefully doesn't happen very often, but sometimes does happen, and we have to be realistic. So once you have these expert reports and depositions, you can make another demand. You could take the old one and supplement it. You could say, you already know everything about liability based on the prior letters. You already know about the damages based on the prior letters. But here is what all the experts and doctors confirmed, including your doctor, who said the injuries are all related. He needs future care. This was all the accident's fault, et cetera, et cetera. Our life care plan is $3 million. Your life care plan is, $1.5 million. Either way, it's a 7-figure life care plan. Whatever the facts of your case may be, not everyone's dealing with cases with life care plans like that, which I understand. But whatever the facts of your case may be, sniff them out and find them. And you should be taking the expert depos really in a way that you're going to have good clips to play at trial. And those clips are usually pretty good to put into a demand as well. So here, it's late in the game, but it's usually, if you get this far and you have a good case, you're probably getting maximum value at this point.
And then the next phase, I don't know if you want to talk about this, right before trial. So this is right after you finish up all your experts. You're about to incur all the expenses of trial. And at this stage, you and the defense should know exactly what the case value is. There should be no surprises going into trial.
Yeah. And, when people say that their case settles on the courthouse steps, when I first became a lawyer, I thought that was like literal, where you're on the courthouse steps and you talk and make a deal. And I'm sure it happens sometimes. It's never happened to me, but I think the metaphorical courtroom steps is very, very real, in that everything is done, trial documents are done. All that's left is that the case needs to be tried. And sometimes it's showing up to the final status conference that helps move the needle. Sometimes it's maybe you getting more reasonable in your demands and, starting to close the gap. And when you're only fighting over this big of a gap versus this big of a gap, a case becomes a lot easier to settle. And a lot of times, a client might not want their case to go to trial. They might not want to deal with the stress and anxiety, and we can push it as far as we can to ultimately their decision. Our job as plaintiffs lawyers is to maximize the result and what we can get. Before that, we had one case where it's kind of funny, and like we joke about it at the office a little, but we wanted X number of dollars, and they were offering $100,000 under X, right? And it would have been hard to pass up the number that they were offering. We said, you know what, like, let's keep applying the pressure. Let's show up. Let's just go and see if they cave and pay the extra money. And we showed up. We had our exhibit binders printed. We had our trial binders printed, at a courthouse with 5 boxes, whatever. And they're like, come on, you guys are really going to go. We're offering you this. But like, hey, this is our number. Whenever you guys want to pay it, let us know. Let us know by Friday, because we're picking a jury Monday, right? And that's what it took. It took, so much of our world is virtual now, but it took going to downtown. It took going to downtown, getting into the courthouse, seeing them there, They came up from Orange County. They probably didn't want to make that drive either, but we forced their hand. And it forced them to have another conversation and pull the extra money that we wanted. And it makes a huge difference for our client because, you know, to us or to them, it might be 50,000, 100,000, whatever. But to our clients, that's real money. You know, that could be a year of rent. That could be, you know, this new car that they've been needing for 25 years that's going to help them live a much more comfortable life. So it makes a difference if you're willing to push it to the limit, right? It costs a little bit more. We had to spend a couple $1,000 on exhibit binders, but obviously it was worth it in the end.
What John is saying and what you referenced before too, like when you're taking these expert depositions, you should be thinking about how is this going to play at trial? You want to create a clip for trial. So that mindset should be in your head from before you file the lawsuit. And at each stage of litigation, you should be thinking about how is this going to play out at trial? All of that is equivalent to value in your case. And so again, the more you show up ready, the more you have every deposition has clips ready to play at trial, the higher value your case will be. I also wanted to talk about the demand on the screen here. We had a case come in that was going to trial like in a few weeks, and we started prepping it for trial. And we realized discovery was already closed at this point. We realized defense had not even deposed the plaintiff. They had done very, very little to build their case. And we decided at that point that we were going to send a demand. And we showed up to the FSC ready to go. The defense attorney didn't even show up in person. And we sent a demand and we said, you know, we just joined in on this case and you haven't even deposed the plaintiff, you know, the bare minimum here. And this exposed defense to a real excess verdict risk. And they ended up paying the full $3 million policy limits the day right before it expired, the day of. So when defense waits that long, trial risk is leverage for you.
And it's all about preparedness. The reality was we were prepared. We were ready. Even though our firm came in 2-3 weeks before trial, we were up to speed and we were ready to go. And preparedness is your friend, whether it's, you know, a week before trial, a year before trial, pre-lit, whatever it is, the more prepared you are, it shows. It shows. And so make sure that you, your staff, if you have other attorneys at your office, that they're prepared and they know their stuff with everything that they're doing. And I think nowadays it's a lot easier to be prepared with technology, and everything is on Zoom. And so we've saved so much time not having to drive from place to place for a deposition, and we could just share screens with our documents instead of having to print everything. But it's still one of the most important parts of our practice.
Yeah, and another, you know, part of our practice that we tend to always do is we usually don't ask for extensions. We try to be ready. Anytime discoveries due, we're prepping it. You know, we're not waiting till the last day it's due and submitting it late. Like, you want to show up ready always, because that is positioning you and your case and your client and the value of your case.
And we just got a question, and I think we can open Q&A now as well if anyone has questions. We just got one question that asked, can you talk about the downside to using 998 offers? Hard to think of one. For a plaintiff, there's very little downside. You can make multiple in a litigation. I would say never make one higher than one you've already made before. So for example, if you made one early on for $1 million, it does not make sense for you to make one for $2 million later. It makes sense for you to make one for lower if you want to, and if it's something that your client will take. And sometimes we'll make another one later on when the case is a little more clear and we have a better idea of the value. And also it might be seen as a more reasonable one, given that depositions and everything have been done. So sometimes we'll make more than one. The downside that I could maybe think of, if I had to think of one, is that if you serve one, it's more likely that the defense will serve one. And if the defense serves a 998 offer and you don't beat their number, then you owe them the expert costs. their expert costs. There's no interest, so 998 is a little bit more favorable to plaintiffs than it is to defendants. That's why I think every case should have one. But it does happen where the defense now makes a 998, and you're like, that's a tough number to beat. We'll see what happens. What I will say, last thing about 998s is, I think there's two schools of thought on the 998. One is, this is, going to be my bare bones number that I can beat at trial, and that's why I'm going to make the 998. The other is, I'm kind of treating it as a demand. I like to treat it more as a demand. I think whatever your 998 number is, assume that they're going to try to work you off of it, right? Unless you're at the very, very end, very close to trial, last ditch 998, and even then, they'll try to work you off of it a little bit too. So be mindful of that when you're making your 998. And I think the argument of, oh, well, our low 998, that was just the number we can beat, our actual demand is X, is really hard to make. It's really hard for insurance carriers to pay something more than a demand that you've already made. So just really keep that in mind.
One more thing I would add to, John and I do email demands quite often, and they work. It's not a formal demand letter that you're mailing out to the defense, but it's just an email laying out, this is the facts, this is what's going on. We are willing to settle at this number. And that has worked pre-lit and during litigation as well.
The next question we have is, what do you do when the defense attorney refuses mediation? It's rare. Usually when that happens, you're not in a good position. I think it's because they think that they have a really strong case. And it's something that you got to be aware of. In that case, I would, kind of stick to the game plan, which is, make the proper 998s, keep making the demands because they have to report them. If you want to mediate the case, I would say, in the demand, something like this is, write a demand letter. Our demand is for this much. Our client is open to, a mediation, and you could even give names of mediators if you want to, and say, let us know if you're interested in mediating in the next, 2 to 3 months or whatever it is. But if they refuse, you can't force them to do it. Some courts do have mandatory ADR, whether it's a mandatory settlement conference or LA's MVP program or resolve law, whatever it is. And a lot of times those can be helpful, especially for, if you're a solo shop or, the expense of a mediation is going to be a lot for the type of case that you're at. Using free court mediation programs is awesome. Frank Chica, great question. Have you attempted to apply pressure early on for settlement by filing a motion for trial preference? What are the risks in doing so? Pros and cons? Thanks again, and help. Oh, this is just a compliment. Thanks for the compliment, Frank. Your question was so awesome that I can't believe that we forgot to even mention this in the webinar. In 100% of our cases where we can file a motion for trial preference, we will file a motion for trial preference. And it should have been number one. That is the number one way to get a case settled. For those of you who aren't familiar, CCP 36 and 37 actually. 36 is for a motion for trial preference, which says, essentially, if the plaintiff is over 70 years old and has some health conditions that could affect their ability to testify at trial, or if they are under 14 years old, period, or if the interests of justice would allow it, or if they have some medical condition that may make it hard for them to testify at trial, even if they're not 70, or CCP 37 says, if the defendant was convicted of a felony, in the causing of the tort, then you could get trial preference. And that means that the trial has to be set within 120 days of the motion. This is a game changer. It changes it from an 18-month wait to get a case settled to now an expedited real 4 to 6 month window. The defense is paying attention. Everything's a little bit expedited, which is great because when we have older clients, it's not fair to them to wait this long to litigate. And when you have younger clients, you don't want, a 12-year-old kid going through a 2-year litigation. You want to try to reach early resolution. I think there are much more pros than cons to answer that part of the question. The cons are you need to know your case and you need to know how complex your case is. And if you are going to be able to get everything done in the 4 months, because at the end of the day, we're the plaintiff, we have the burden of proving our case, and you need to be realistic about all the depositions you need to take, any motions that might come up, whatever it is, you got to be realistic and do it. You can
I
make,
will say too,
go ahead.
with preference motions, they usually will get granted because the code is so clear. If they're over a certain age, or they're a minor, or they have a condition that they can't, wait long, the judges usually will grant trial preference, but I remember some that got granted, the judge will say, like, you better be ready. We're not gonna wait. So what John's saying is true. You need to really know your case, and you need to be ready to try it that fast.
And look, sometimes we'll also meet and confer with the defense on a preference motion and say, hey, we're going to file preference. Do you want to just agree to 6 months instead of opposing the motion, or 8 months, whatever? And that gives us both a little bit more time. You can make a preference motion at any time in a litigation. So if your client turns 70, or if their condition gets a lot worse, you might consider making a motion or making another one if you made one before that was denied. Or, if it's a case where a lot of work needs to be done, you can wait until you feel like you're at a good spot and then make the preference motion. And if there's already a trial date on calendar, you might even ask the court to just take that trial date and please give it, preferential treatment, which means it cannot be continued, because defense lawyers love continuing trials. And having a trial that cannot be continued is great leverage too.
But yeah, generally we do always, for the most part, file preference motions for the cases where the plaintiff fits that criteria, and it does absolutely help to settle your case and to get the highest value.
Yeah. And another question we have is, what about the danger of a 998 policy limit demand where the policy limits are nowhere near enough compared to the value of the damages, so the carrier has incentive to accept and settle at a deep discount? Good question. Totally depends on your case and what your client wants. I mean, the reality is it's hard to get personal assets from people. So if it's a case where you're going to take the policy at some point anyway, then that's a good time to do it. If it's a case where you're not going to take the policy, then don't make the 998 for the policy. Whenever you do make a 998 at any point, make sure it's a number that you're okay with taking, because they might sign, right? They might accept it. You got to make sure you get written authority from the client to do it, explain it very well, because if they sign and you're thinking, oh shit, I actually wanted more than that, it's too late. So you got to make sure you know. And repost the webinar materials. I think the webinar materials are being shared by BHBA, and they're typing an answer to you right now, Gene. Any other questions about getting your case settled?
I had one question for you guys. Early in the presentation, you mentioned the disclosed policy limits when you're doing a pre-lit demand. How do you get that information? Or if you ask the adjuster for it, to get it from their client and it's refused, how do you handle that?
Awesome question. Happens all the time. More often than not, I think nowadays we're not getting what the limits are. There are a couple of ways that we handle it, depending on the case. If it's a case, first of all, if it's a trucking company, there's at least $1 million, right? So that informs you. If it's, a guy driving a 1992 Toyota Corolla, you're probably not dealing with an umbrella. So that should inform you a little bit too. There are a couple ways that we handle it in terms of the wording of our demand. If we want whatever the policy limits are, if we think that we would accept them, understanding that they might be 30 or less or whatever, then we will just say we demand the full policy limits, including any excess or umbrella limits, and we need a declaration of no other insurance and yada, yada, yada. If we are worried that there's not enough insurance and we're not sure if we would even take the insurance because, hey, there's this guy who we think might have some personal assets and we think might be underinsured and they're not disclosing and it's a little, iffy. We have a case like that right now, actually, where they're not disclosing and it's a big injury and we don't know what what the policy is. We're just going to make a demand for what we think the case is worth. And so we're making a multi-million-dollar demand, and we're going to let the insurance company say, hey, we got your multi-million-dollar demand. We're going to offer our $250,000 limits. which we didn't know was 250 before, but now they've offered it and they know. Technically, we don't have offer and acceptance because we didn't offer to settle the case for the policy limits. We offered to settle the case for millions, right? And they've now offered to settle the case for 250, and we could decide if we want to accept it or not, right? And now we have clarity, we have an idea, and we have a firm offer for the client to decide. So those are the couple of ways to do it. Mediator from Northern California, welcome. The time frame filing a complaint to go to trial in LA, how long does it usually take? My information is that it can take close to the 5-year dismissal deadline. Depends. That does happen. I think that typically happened more for some cases that were kind of dealing with COVID stuff back in the day, but also that usually happens when plaintiffs' lawyers agree to continuances and plaintiffs' lawyers aren't on top of things. And, you know, because if we're on top of things and we're pushing it forward and the defense isn't, we just keep pushing. We keep our foot on the accelerator and don't agree to any continuances. And eventually the court is going to deny it. Might give them the first one, might give them the second one, but eventually that continuance is going to be denied. And you got to have a trial date to get a case settled. That's it. Like at the end of the day, that's what matters. You got to have a trial date. We at our office, the policy is to never continue the trial. Be prepared, never continue the trial. There are some exceptions that we make here and there. But for the most part, we will never agree to continue a trial date because it's the only way that a case is going to get resolved. And we'll tell the defense lawyer that. It's like, look, I hear you. I know you want the trial date to be continued, but we both know it's only going to settle if the trial date sticks. Curious if we have ever demanded mediation, but only with our preferred mediator. I mean, we don't have just one mediator that we mediate with. We usually won't agree to a mediation with someone that we don't like or someone that we don't trust. For the most part, though, in my experience, you want the defense to be comfortable with who the mediator is. You want the carrier to be listening to this mediator because we're presenting a good case and we're going to have a good mediation brief and we want them to be able to get money from the other side. But we still want it to be someone that we can trust. So usually we pass around some names and it ends up not being an issue. How to approach a miscarriage loss from a T-bone car accident. That is a case-specific question. Hit us up offline. I have some thoughts on what you can do to get that one resolved. Okay, let's see any other questions that we missed. Brigitta, any more stories? We got a few more minutes. Oh, what kinds of injuries treatment reach the bar for a $1 million pre-lit settlement?
Good question.
Do you want to take this one, Brigitta?
Sure. So I think about that like, you know, a couple broken ribs or like a couple scratches is not going to meet the bar on a $1 million pre-lit settlement. It needs to rise to the injuries are significant, meaning like broken bones that led to surgeries or pain that's still existing today, and it's real injuries that, you know, the medical records are telling you as well. I don't know if you have anything else to say on that, John.
I think the short answer to it, one, it's hard to answer that, but the short answer to it is you probably need a surgery at some point, and depending on the surgery, it might be borderline. But you probably need at least a surgery to get to the $1 million threshold.
I have a good example of this.
Yeah.
I had a case where a woman was hit in the crosswalk. She was walking and she broke her pelvis and she broke another bone. And she went to the ER and did not have a surgery. And we got the $1 million policy. The liability was really clear. I mean, she was walking in the crosswalk with a walk signal and a guy was making a left-hand turn and truly just did not look. So the liability was great. And, you know, her damages, she didn't have surgery, but she was hit pretty hard. She hit the ground and it was traumatic to go through that. She had some broken bones and we were able to get the policy on that. So I guess it varies. But if you have amazing liability and pretty significant damages, you can get the million, or you should be able to.
It's always worth a shot. It also depends on insurance. You know, is there only a million in insurance? Is there an umbrella? If there's an umbrella, then they're not really as afraid of risk. But you know, the joke I like to make is the easiest way to get a $1 million settlement is to have a $2 million case, right? With a $1 million policy. Let's see. Non-economic damages are serious. 100%. It's harder to quantify. The example that this person who asked the question is, if an actor can't audition for a part because of the injuries, I think that would go to lost earnings. And it might be a little bit speculative, but it's something that's going to be hard to prove pre-lit, and they might want to depose the plaintiff and get some more information about something like that. Knee meniscus surgery, shoulder rotator cuff surgery, are they worth $1 million? Maybe. Depends. Could be. If it's both in the same case, then much more likely. But it depends. Look, I don't think there's a cookie cutter answer. I wish that there was to this is worth this. Usually there's ranges for cases. A lot of it depends on the plaintiff. A lot of it depends on liability, who the insurance carrier is, who the defense lawyer is that you draw. There's so many different factors. You know, how far you're willing to take it. If you have a knee tear and a shoulder tear and they're both surgeries, maybe you'll get offered, you know, 350 or 500 pre-lit, but if you take it all the way to experts, you got a much better shot at getting, you know, $1 million or close to $1 million.
There's a great question. Do you include jury verdict research with a demand letter? So something we always include in our demands is our firm's verdicts on cases that are similar to the case that we're litigating. So we have, you know, I literally have a list of all of our, for example, traumatic brain injury results that we've gotten, and I'll include that list and say, you know, our firm's gotten all these results for similar cases, and it does show the value. You also can do it with verdicts in your where the case has jurisdiction, other plaintiff verdicts for the same injuries. So you can show, like, you know, this venue does get good verdicts for these injuries.
Yeah, I agree. 100% something good to do, something that we include in demands. Does it make a difference if a public entity is the defendant as part of pre-lit settlement? I would say yes, in that public entities almost never settle pre-lit. It's very rare. You'll make your government claim, they'll deny it, they'll wait for you to file the lawsuit. They don't want to pay until and unless they have to. So I don't even really bother sending public entity pre-lit demands at this point.
Yeah, and I mean, I guess it's good in litigation for maybe a bad faith case, but generally I agree with John. It's not, you wouldn't need to or want to do it pre-lit with a public entity.
Yeah. Here's our contact information. Both of our emails were in West LA at the Panish firm. If you guys ever want to stop by, if you have any cases that you want to discuss, whether it's one that you want to consider co-counseling on, or just one that you want us to take a look and give feedback on value or strategy or whatever, happy to do so. We both really love our jobs and really like looking at cases. I think it's fun and interesting with as much that happens there. So just feel free to shoot us an email anytime, where everyone at the firm is super helpful. We've handled pretty much every type of case that you can imagine, I think. So happy to share, you know, specific templates or whatever you guys need as well.
And then there was a question about email for referrals. You can, or you just sent your email. You can also email either of our emails and we'll respond regarding any referrals or cases. As John said, always happy to discuss. Anything you have questions on, happy to help in any way that we can be a resource. Like he said, we both really do love our job, and I love talking about our cases and helping people as much as I can.
Awesome.
Alrighty, this concludes today's presentation. Thank you so much, John and Brigitta, for an excellent presentation, and thank you so much to our audience. Have a great day, everybody.
Thank you.